IP Jagruti presents IPR at a Glance, Episode 6, Case Studies of Design Registration. Welcome to our 6th episode of IPR at a Glance. In the last episode, we talked about design registration, its importance and procedure of filing design registration. Today, we will share some case studies on design infringement. So, let's begin. The first case study that we would talk about is Rajesh Masrani vs Taliani Design Private Limited. This landmark judgment of the Delhi High Court draws the line between design and copyright law. The plaintiff in this case, Taliani Design Private Limited, is a private company under the creative leadership of Mr. Tarun Taliani. It has major presence in the fashion industry in India and enjoys a global reputation and has over 80 outlets in 20 countries. The plaintiff claims that the drawings which are made in the course of developing the garments and accessories are artistic works under Section 2C(I) of the Copyright Act 1957. The patterns printed or embroidery on the fabric developed by the plaintiff are also claimed to be artistic works. The plaintiff alleges infringement of copyright by the defendant on the ground that there is a colorable imitation or sustainable reproduction of the plaintiff's fabric prints, including the underlining, drawings, sketches thereof, or of any other of the plaintiff's copyrighted work, including works of artistic craftsmen or the literally artistic works. The issue before the Honorable High Court is to determine whether the patterns made by the plaintiff on the fabric qualifies for design or artistic works. Held, the court was on the opinion that the plaintiff's work is entitled for protection under Section 2C of the Copyright Act and is original artistic work. Since the work is an artistic work which is not covered under Section 2D of the Design Act 2000, it is not capable of being registered under the Designs Act, and the provision of Section 15(2) of the Copyright Act is not applicable. Key observations of this case. The court made it clear that Section 2D of the Designs Act 2000 does not include any artistic work, as defined in Section 2C of the Copyright Act. The court further explains the situation mentioned under Section 15(2) of the Copyright Act that if the work in question could have been registered as a design under the Designs Act, but hasn't been so registered, then author or creator loses any copyright in such work. So here is the last case study of the day of design infringement between Reckitt Benckiser Limited versus Wet Limited. This case had a significant impact in the world of designs and intellectual property law. In this case, Reckitt, British multinational consumer goods company, alleged that Wet's hair removal product with the design of S-shaped spatula infringed their copyright in the design registration number 193988 in respect of S-shaped spatula marketed with its hair removal cream named Wheat in India since 2004. On the other hand, Wet Limited, an US-based pharmaceutical company, contended that Rec's design lacked originality insofar as the same had also been registered, published as well as used in countries other than India before the Indian registration had taken place in reality. In addition, Wet also alleged that the Reckitt had concealed the fact about the prior registration of the design in foreign countries. The issue before the full bench of the Delhi High Court is to determine whether a design registered outside India can constitute ground for cancellation of a design registered in India under Section 19(1)(a) of the Act and the meaning of prior publication under Designs Act. Held, the full bench of the Delhi High Court clarified that the mere existence of a design in the records of the Registrar of Design in a conviction country may not amount to prior publication in all cases. With regard to the use of the design, the court observed that Division Bench has approved the decision of the single judge on the existence of prior publication, as the article in question was found to be in actual use before registration in India and thus directed both parties to appear before the single judge for further proceedings. Key observations of this case: the court held that prior publication as the ground for cancellation was no longer limited to prior publication in India, but was extended to include prior publication anywhere. However, the court concluded that mere registration of a design in conviction country was not a ground included under Section 19(1)(a), as the legislature consciously did not include or any other country in Clause A. Thus, it can be concluded that only design registered in India constitute grounds for cancellation of another design subsequently registered in India. Through these case studies, we aim to raise awareness for design registration, its registration process and compliances involved, including other intellectual property rights. Stay tuned with us to get more information with our next episode of IPR at a Glance, only at IP Jagrati. Innovation is our tradition.